The world of college athletics is changing fast, and name, image, and likeness rights are at the center of the conversation. On this segment of Legal Connections, Professor Peter Goplerud speaks on NIL and sports law to help us break down what these changes mean for student athletes, institutions, and the future of sports. Thank you for joining us.
Well, thank you for having me.
First question for the audience, please explain what NIL is.
NIL is essentially the right of an individual, you and I could do this, to monetize, to be compensated for the use of their name, their image, or their likeness. In the college athletic world, that was until 5 years ago impossible, because any athlete that would do that would be declared ineligible based upon the NCAA's long-standing principle of their athletic programs being for amateur athletics, not professional athletics. And under the NCAA bylaws, any use of name, image, and likeness would be playing on your athletic abilities, and in the NCAA's eyes, make you a professional. Mm-hmm. But that changed in July of 2021 as a result of several states, including Florida, passing laws that changed all that and allowed for college athletics, despite whatever rules might have existed through the NCAA, to benefit from the use of their name, image, and likeness. The NCAA quickly put into place some interim policies confirming that they would now allow it.
Okay, and just to continue with some of the basic concepts, tell us the difference between NIL, pay for play, and treating students as employees.
Well, the NCAA continues even after July of 21 and a number of changes that have occurred to prohibit pay for play. Mm-hmm. The NCAA and 4 of its member conferences, the so-called Power 4 conferences, the SEC, the ACC, the Big Ten, and the Big 12, settled a lawsuit that focused on both NIL and potential for pay for play. The settlement and continuing NCAA rules still prohibit pay for play. The settlement, however, allows the schools now to directly pay their athletes up to $20.5 million per year in terms of the total amount that they can pay in their athletic programs for the use of their name, image, and likeness. But there are many people that feel that that has sort of blurred the distinction between name, image, and likeness and pay for play.
Right.
It is all of that's being supplemented at many schools with third-party NIL deals that take the spending of the schools or for the athletes above that $20.5 million mark. And under the terms of the settlement, that increases every year, so that next year it's going to be, I think, $21.3 million.
Okay, and so, and also I do want to point out to the audience that NIL, before all of us became familiar with it as it's attached to athletes, is in general the area of law that we call publicity rights. And there is no federal publicity rights statute because these are privacy rights controlled by the states.
Yes.
What do you foresee? Do you foresee these things? Where do you think these policies are going with these laws?
Well, the NIL policy, the settlement of the litigation known as the House settlement, House versus NCAA was the name of the case, coupled with and the last part of your question regarding employment. Mm-hmm. All of that is at the moment I think described pretty accurately by most people as a very chaotic situation within college athletics, one that is putting a tremendous amount of pressure on the athletes, the administrators, and the coaches to figure out how to move forward. There is, in addition to all of that, at about the same time that the NCAA relaxed in light of the states passing NIL laws regarding athletes, the NCAA relaxed its restrictions on athletes transferring. So you put into a bowl NIL, school payments for quote unquote NIL, the employment issue, the transfer portal, and then add into that athletes, because of, among other things, the availability of NIL, seeking to stay eligible for longer than the typical 4 years.
Right.
And it is, it's essentially something that those who work in the area and teach in the area, and I do both, basically have to keep an eye on things literally every day, because there's new litigation being filed, new decisions coming down. Just in the last 10 days, there have been, I would say, a half a dozen very critical court decisions coming down related to one or more of these areas that are being litigated and being discussed at the policy level. The NCAA and a number of the schools and the conferences are lobbying Congress very heavily to give the NCAA antitrust protection, because part of what has happened is over the last several years at the federal level, the NCAA has lost a number of cases based on arguments that their rules with regard to eligibility, with regard to NIL, and so on, violate the federal antitrust laws. And so now the NCAA has been for several years, without any success so far, seeking protection from Congress.
Well, we appreciate you coming and giving us sort of the aerial view of this very complicated area that, of course, requires attorneys to make sure these contracts are fair, and knowledgeable people who are plugged into these quickly changing rules. So thank you very much for coming on.
Mike, thank you so much for having me.
The professor's insights have provided valuable clarity on how these changes are shaping opportunities for student athletes, schools, and the broader sports community. We truly appreciate hearing his expertise and helping our audience stay informed on an issue that continues to transform the game both on and off the field.